There's my mom. I guess my daddy did. He didn't make it.
All right, looks like we have everyone. So welcome to the 7th District Court of Smith County, Texas. Time is now 1:32 p.m. on Wednesday, November 10, 2021. Court is now in session. The proceedings are official, on the record, and are being recorded. Counsel and all present are instructed to act as though you are physically in the courtroom with us, and all parties are instructed not to record these proceedings. We are live on YouTube in order to comply with the open courts provisions of the Texas and U.S. constitutions and other applicable law. The Smith County Courthouse, the 7th District Court and courtroom are open today, as we have been throughout the COVID-19 pandemic months. As with all proceedings, violation of these instructions are subject to contempt proceedings, so accordingly, please exercise proper courtroom decorum at all times. Our next cases are the State of Texas versus Randal Wright, cause number 007-1620-20, here for an open sentencing on an enhanced first-degree felony driving while intoxicated charge, and then we also set his companion case 007-1112-20 for a status hearing once he conclude the sentencing in the DWI case. So with that, I'll start with the state's appearance and announcement. Mr. Vance.
Richard Vance for the state of Texas, and no objections to proceeding through Zoom.
And on behalf of the defense?
I'm Jarvis on behalf of Mr. Wright, and no objection to the Zoom process.
I can just barely hear you.
And you felt like it was appropriate for you to take matters into your own hands to put out fires, for example.
I think I got it turned down for some reason, Judge. If I can figure out how to turn it up, I'll turn it up.
All right, we'll give you a moment. Normally you're louder than you are today. You don't want the court reporter throwing staplers at you.
Can you hear me any better now, Judge?
No, still pretty soft.
So you felt that you wanted to go out and
There we go.
help people.
Okay, how about now?
Much better. All right, I'll let you start over.
Is that any better?
Yes, sir.
Provide first aid.
Better.
Normally in our
Okay.
regular society, that's something that we call 911 for, right? Normally, yes.
Okay, can you hear me now?
We can hear you now.
Okay, I can't hear you though.
Well, Mr. Vance, you hear me?
Yes, Your Honor, I can.
I hear Richard now.
Ms. Primus, you hear me? Yes.
I think it was my system, Judge. Do it.
Now you can hear us?
Yes, Judge, and John Jarvis on behalf of Mr. Wright, no objection to the Zoom process.
All right, Mr. Wright, if you'll raise your right hand for me so I can swear you in. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in connection with your case before the court, so help you God?
I do.
All right, you can put your hand down. If you'll state your full name for the record, please.
Randal Walter Wright, 112561.
Mr. Wright, we're here on the Zoom hearing app. Your lawyer and the state's lawyer have agreed to have the hearing held in that fashion. We've been using the Zoom hearing process since April of last year because of COVID-19 to try to keep people safe. Do you agree to have your hearing held in that fashion as well?
Yes, I do.
All right, sir. You were here previously. In lieu of going to your jury trial, you elected to enter a open plea of guilty on this felony, enhanced felony driving while intoxicated charge. We recessed your hearing after you entered that plea, and I ordered a pre-sentence report to be completed. That report's now been completed with, I think, an addendum or two. The range of punishment back then and still today is anywhere from 25 years to life in the penitentiary. You understand that?
Yes, sir.
We talked before that, at least according to the court's notes, apparently the state made you an offer that you could plead guilty in both cases for a 25-year sentence on both, or if you only wanted to plead guilty in the DWI case, they would apparently offer you a 40-year sentence, and they would 1245 the other case, both of which options you've rejected and elected to have the court to do an open sentencing that we're here in the midst of now. Do you recall all of those things?
Yes, Your Honor.
All right. Let me get my pre-sentence open. I meant to do that when I started and forgot. All right. I have actually one pre-sentence, but it came to the court in 2 different volumes. And then I have an addendum that was received, I guess the next day, it looks like on November 4th, maybe for me. Have you had a chance to sit down with Mr. Jarvis and go through the pre-sentence and the addendum, Mr. Wright?
Yes, I have.
And are you ready to proceed with sentencing here today?
Yes, I am.
All right, Mr. Jarvis, do you have the pre-sentence and the addendum?
I have volume 1 and 2 that was delivered on the Digify on November 1st. I do not see an addendum, Judge.
All right. Looks like the addendum is a letter from Deborah Burns, the defendant's sister. It is just the cover page in that letter. I presume that you probably sent that in, did you, Mr.?
I did not.
All right, well, probation got it somehow. Ms. Primus, could you email that to Mr. Jarvis, or I can do it if you cannot?
Your Honor, I can email it to Mr. Jarvis.
Okay, if you'd go ahead and do that for me, and that way I'll give him a second to look at it. As I said, it's only 2 pages, so it's not a very lengthy document that he'll have to look at. Pretty normal support letter from family members, I would suggest.
Things were fine. No tension, no friction, no nothing. Fair to say?
For the most part, other than Mr. Rosenbaum,
He was the only one
and threatened, yes,
that you saw.
yes.
Can we please play exhibit number 18 at the 1 hour and 22 second and 22 minute and 14 second mark?
Your Honor, it has been emailed, and I also CC'd you on the email.
All right, thank you, ma'am. All right, Mr. Jarvis, if you'll let me know when you get that, and then I can send you and Mr. Wright to a breakout room to let y'all go over it.
Okay. Lamia, which is John Jarvis at Yahoo?
Yes.
I have not received the CC yet, so maybe in the black hole of email.
I have it, Judge.
All right, let me get y'all sent out to a breakout room then.
Can you please play from this point?
All right, Mr. Wright, I'm going to send you and your lawyer to a breakout room so y'all can go over this addendum to the pre-sentence report. As I said, it's only a, excuse me, it's a single letter, so it shouldn't take y'all too long. But once I turn this on, there'll be a button on your screen you'll have to punch to take you to that room. We won't see or hear you, and y'all won't see or hear us, but we'll be here on the record waiting for y'all's return. So here we go.
All right. Now can you, PJ, you got to put that join, I guess, right there. Okay.
All right, Mr. Jarvis is gone. Looks like the jail screen is frozen. All right, now they're there. And I got the copy as well. Cool.
Do you think that looks like friction?
A little bit.
And you witnessed that, didn't you?
I didn't witness what Mr. Collet did. I didn't see that.
But you saw the reaction from the crowd, right?
Yeah, a little bit. I wasn't really paying much attention to that.
Would you agree with me that it seems that the crowd was reacting to members of your group
Yeah, I'm back,
going out on the
Judge.
street and trying to
Thank you.
interfere with what was going on off your property?
I'll close the room, which will bring your client back shortly.
And in fact, Kriston Harris, who made this video, specifically told you to stay on your property and not go out on the street and try and put out fires or interfere with any of that stuff. Just protect your property. Isn't that what he told you?
I believe so. I was just going to grab the garbage can, the dumpster that belonged to the car source that was on the car source property.
This is before.
All right, Mr. Jarvis, you had a few moments to go over that addendum with your client. Any issues on the addendum?
No, Judge, it was just a one-page letter. We read it.
Yes.
Does the defense have any proposed changes, corrections, additions, or deletions to the pre-sentence or the addendum?
Not that I'm aware of.
Yes.
Mr. Vance, state also have the pre-sentence and the addendum.
This was a crowd that would not
We do, Your Honor.
favorably.
Does the state have any proposed changes, corrections, additions, or deletions?
Judge, the only issue that I noticed, it appears that on 2A of the criminal history, it indicates a DWI third from May 29th of 1988. And it lists that as a 5-year deferred probation was the disposition in 1990. I have a certified copy of the judgment and sentence that there was actually a revocation of that cause number in which the defendant was sentenced to 5 years confinement. I double checked that because that's one of the priors that was used to enhance him to make him 25 to life. So it was not just a deferred on that one. It was a deferred that led to a revocation. That's the only thing that I noticed, Judge.
All right, I'll make that correction. Mr. Jarvis, were you aware of that?
I was, Judge, and I knew that was the prior on this case, and that's what, that along with the 2010 charge is what bumped this to habitual.
Right. All right, any other changes, Mr. Vance?
He seemed like a nice guy.
No, Your Honor.
Court will take judicial notice of the pre-sentence and the addendum along with this update provided by the state as to the criminal history. State have any other sentencing evidence in the case?
State does not, Your Honor. I'm trying to review the file. I believe somebody else did the plea, but there were pleas. Okay. There were pleas of true on the prior, so in that case, we have no other evidence.
He did not.
Yes, sir. He has stipulated to it and pled true to those.
Yes, Your Honor.
All right, Mr. Jarvis, defense have any additional evidence to present?
Judge, I have one witness.
exhibit
All right,
number
the one that's there with you.
Yes, Judge.
All right, ma'am, if you'll raise your right hand for me so I can swear you in, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in connection with the cases before the court, so help you God?
Yes, I do.
that one up there?
All right, you put your hand down. If you'll state and spell your name for the court reporter, please.
I'm Geneva Driggers, GENEVADRIGGERS.
All right, thank you. Good. You've spoken up nice and loud, so just keep doing that. Mr. Jarvis, I'll let you proceed.
Thank you, Judge. Ms. Triggers, you're Randall's mother, is that correct?
Yes, I am.
So you're well aware of, I guess, Randall's history, criminal history, and mental history.
Yes, I am.
And even as a child, did he have issues with, I guess, an imbalance in some manner?
Yes, he did.
And was he placed on any kind of medication as a child?
Yes, we tried him on when Ritalin come out. He was diagnosed with like the ADD,
Indicate that you're gonna run up
the
there.
deficit disorder when he was a child.
Correct.
Couldn't be still.
And as he got older, did he continue to have problems with medications and mental health?
Yes,
And he actually spent some time in the Rush State Hospital.
yes, he did.
And how long do you think he was there?
Approximately, if I can remember correctly, it was around 2 years.
Okay.
They were
And
trying to place him on, get him on the right medication, and they never did.
okay. And in addition to the Rush State Hospital, has he been a patient of the Andrews Center?
Yes, he has.
And what has he done at the Andrews Center, to your knowledge?
Well, Dr. Crow was his doctor, and he tried him on different medications. And there was one that I noticed a real difference in Randall, made him calm. His thinking was better, and that was Seroquel. I noticed a big difference in Randall's attitude, his behavior, and he's getting along with people. He was just good on that right medication.
And the medication's kind of come and gone over the years. Sometimes he can stay on it, sometimes he can't.
Right.
Back in 2020, was he in some kind of counseling or some rehab type facility?
He was in, he went to Henderson, and that had been, what, 2 years ago? Now, I guess it's time's passed. 2 years ago, I think.
Okay.
He went to Henderson, and that was the episode, with his dad, that he had just gotten out of, rehab. They had given him some type of medication. Then,
And they let him out for the weekend back.
yeah, right. Then he was supposed to go to University Hospital, supposed to admit there, but they were waiting on a bed.
Okay. So I guess needless to say, he's had lots of imbalances, mental health care over the years.
Yes.
Okay.
Then I noticed a lot in his behavior. Times he's never been violent or anything like that, but some verbal irritability, things like that in my home.
And when he's on his medication and it's working,
He's great. He's fine on the right medication. On that he's on Seroquel. I'll just say it. That's the best I've ever seen. His demeanor, his attitude, his behavior when he was on the right medication.
and I guess needless to say, he has pretty much full family support from everyone.
Yes. And all the family loves him and wants to help him and
Okay.
in any way they can.
Okay. Judge, I'll pass the witness.
Because you expect
Mr. Vance.
that if you go out in that crowd
No questions, Your Honor.
to try
All
to
right,
get
sir.
medical service,
Any additional evidence, Mr. Jarvis?
No, Your Honor.
Defense rests.
We rest.
State have any rebuttal evidence, Mr. Vance?
No rebuttal evidence, Your Honor.
All right, I'll hear the state's argument then.
They were to reconvene,
Your Honor, this is one
and if somebody
which I'm sure the courts looked at the PSI.
watch out.
I think that
got AR-15.
it's kind of hard to figure out exactly where to start. There's so much. The nature of the offense in and of itself is particularly disturbing. Not just a DWI, it's as the report indicates, a DWI where another vehicle was struck. Then, according to another witness, he attempted to leave the scene of the accident that he caused, almost striking another vehicle. Then, after trying to leave the scene of the accident, he gets out and starts dumping beers out and attempt to cover up what he did. Then, as the reports indicate, when he's confronted by law enforcement, he is clearly intoxicated, slurring his speech, and when asked about giving some sort of blood or breath, it's not a matter of just rejecting it. He becomes belligerent and rude to the officer. So if you're just looking at the facts of a DWI, those are all particularly egregious facts. Then you do that in light of the criminal history. Looking at that, he has a total of, I believe it was 19 convictions, 2 of those being felonies. Those 2 felonies being driving while intoxicated. So we have a individual with at least 4 prior DWIs out on the streets drinking again, striking another vehicle, attempting to get away, attempting to get rid of evidence, being belligerent to an officer, and then pop things off. It wasn't a matter of he was just a little over the limit. He was at a .187 over 2.5 hours after the incident. So as far as the nature of the offense and the type of criminal history, the felonies in particular, particularly egregious. Then looking at the other misdemeanor offenses that he has, I know there's been some testimony that he's not particularly violent, but as the court can well see, there's several, at least 2 different assault family violence or assault convictions, along with a pending injury to an elderly. Another aggravating factor is that injury to the elderly case occurs on June 12th. This DWI happens on August 10th of 2020, meaning all of this happened apparently while he was out on bond for a 25 to life offense. So when you look at all of those factors, just the nature of the offense, the history, and the fact he's on bond for a 25 to life, picking up another 25 to life, certainly it requires a stiff sentence. Then also looking through these records, there seems to be a tremendous amount of evidence that while he does have some mental problems, you can only come to the conclusion that a certain amount of that's probably been due to the fact that he's routinely used cocaine as recently as 2020. He's gotten help. He's been to the Horace State Hospital. He's been to the Andrews Center. He doesn't change. And talking of his mental condition, where he's at, again, there's no mental condition that requires you or forces you to pick up a drink and drink to a .187 and drive. There's no mental condition that makes you do that. That is a choice, and that's a choice that he's made. And I think maybe in the end, the most egregious factor is the fact that you can tell, and as this indicates and the PSI indicates, he's got a tremendous amount of family support. He's had family that's there for him, family that's supporting them, has tried to get him treatment, tried to do everything they can. He simply chooses to continue to break the law, and in that process, put innocent people in danger by driving on the roads intoxicated. So looking at all of those factors, the nature of the offense, the history, the seriousness of the offense, when it was committed, and how the state believes an appropriate sentence on this particular case would be 50 years confinement.
Mr. Jarvis, on behalf of the defense.
And Judge, as I review this, Mr. Wright's, he's not young. He does have a history. It starts, 79, and it's misdemeanors, a couple of misdemeanors. And then, of course, he does get the 5-year sentence on the 88 DWI. I think he gets a 5-year sentence on the 2010 DWI. So really his pen time trips really have not been real significant to jump up from 2 to 10, from 2 to 20, whichever one it might be, to 25 to life. So anything he gets is going to be at least 5 times higher than what he's got in the past. And as I review this, I look at, I guess I take into account the things that have gone in his life, talking to his family, that he has had a lot of mental problems. Self-medication is always a terrible idea, even though it happens a lot, as well as the medications I guess he got from the Andrews Center that probably helped him. I would assume the Rush State Hospital probably got him at least close to normal before they released him. But, you know, if he doesn't have that ongoing help from the medical professionals, and certainly it's a problem. You know, he's continued to maintain his family support throughout this. And Judge, I guess given all this, given he's coming in, you know, he's pled out on this. You know, he did have a .18. And they're not the best circumstances, but anything you give him is going to be 5 times higher than what he got last time, and that's what we'd be asking for, is a 25, which is we know it's the minimum. We still think it's going to send a message to him at his age, because he's close to 60. So whatever he gets, he's going to spend, you know, a good bit of the rest of his life in the pen. And then he's going to come out on parole, which will also help him for the years he has left when he is released. So the judge, that's what we would ask for, and that's why we would ask for it.
Any rebuttal, Mr. Vance?
No, Your Honor.
All right, court has reviewed the pre-sentence, both volumes and the addendum that was presented, as well as the court's file. Court finds, based upon the defendant's plea, well, I've considered the full range of punishment, 25 to life, as I'm required to do, based upon the plea of guilty and pleas of true. The court finds, based upon the defendant's plea of guilty and pleas of true, he's found guilty of the felony driving while intoxicated charge set forth in the indictment. I find it's true. The jurisdictional paragraph that he stipulated and pled true to, I find also is true. The 2 prior felony DWIs that he stipulated and pled true that are part of the indictment and the stipulation, considering the fact that this is a wreck case, a .187 blood alcohol testing case, the defendant's 5th DWI, 3rd felony DWI, the court finds that an appropriate punishment is 40 years confinement in the institutional division, along with any unpaid court cost. The court does assess the mandatory $100 fine that was included in the open plea papers. The court also assesses the DPS lab reimbursement of $60 to reimburse the lab for the testing, for the blood testing. Court has signed the trial court certification indicating that it is not a plea bargain case, so the defendant will retain all of his appeal rights on the case, and I'll cover those here in a moment. Now, under Texas law, the defendant is ineligible to possess a firearm or ammunition. Beginning now, possession of a firearm or ammunition could lead to additional charges against you. Firearm is a legal term, and you should read the written form that we've already provided to you to see what devices qualify as a firearm and that you're ineligible to possess. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or questions about how long your ineligibility to possess a firearm or ammunition lasts, then I recommend you contact any attorney of your choosing. As I indicated, you do retain your appeal rights. You've had court-appointed counsel up to this point in the case. If you wish to pursue an appeal of the court's decision today, all you need to do is let Mr. Jarvis know that. He'll file a motion to withdraw and let us know you told him you wish to appeal. We've got 2 different lawyers that we appoint to handle appeals, so we appoint one of those to pursue your appeal for you. The law says you've got to file that appeal within 30 days of today's date, so you don't have to make an immediate decision, but you do have to think about it and make it fairly quickly. Secondly, as I indicated earlier, we do have the status hearing on the companion case, the enhanced habitual injury to a child charge in 007-1112-20. State intend to carry forward on the prosecution. If so, I'll put it on our next available trial docket so that we can get that one resolved as well.
Your Honor, I anticipate, with all candor to the court, I've actually had the victim's family in here. They've spoken with me on multiple occasions about not prosecuting that other matter. I think in light of the sentence, I anticipate I'll probably be dismissing that, Judge. But that would be what I anticipate I'm going to do, Judge.
All right. Well, we'll give you a week to make that decision. If we haven't heard anything by way of a dismissal, then we'll get it set on the December 6th trial docket.
Yes, Your Honor.
All right. Anything else on the state on either of these cases?
No, Your Honor.
On the defense, Mr. Jarvis?
Judge, I would ask that you make a finding he'd benefit from both mental health care as well as alcohol counseling.
Court would make that affirmative finding in the court's judgment and here on the record for making him presumably eligible for that type of treatment down there.
And that's all, Judge.
All right. Mr. Wright, I muted your microphone, but any questions? You'll need to unmute if you have any. If you have any, you'll need to get them to unmute your microphone.
Okay, can you hear me now?
I can.
Okay, anyway, what Mr. Vance was saying about that police report, he's saying
We're not talking about that.
I was just saying I didn't ever try to leave the scene of the accident. So, and that's all I'm trying to say. I was just trying to make that clear. I did throw some beers out, and I mixed some prescription medication with that alcohol, but I did not try to leave the scene. That police officer had that all messed up. You know, but it's not true. I ain't got no reason to lie about it now. I did drink 3 beers, 3 tall boys. That's what y'all want to do, give me 40 years? That's, you know, I'll deal with it. That's what God intends for me to do. I will do it. You know, but a lot of that in that police report was not true. You know, what he stated in there. You know, I did not try to leave the scene of the accident. Only I proceeded out, you know, to get take a left there at the stop sign. Anyway, I could not see around me, so I proceeded out. And that Spanish guy from Mexico, undocumented, he come up the hill right there, and he clipped the front of my truck. He didn't have no insurance. He's the one that run over there and grabbed my keys to my vehicle and pulled them out. I had my window down. So I threw the beers out. I ain't no sense lying. I didn't want, you know, I know I drank 3 beers. I used to drive an 18-wheeler. I know how to drive. That guy was speeding. Anyway, he was trying to get paid because I had full coverage on my truck. That's all that amounted to, Your Honor. I just wanted to make that, you know, noted for the case. You know, the truth. I did not try to hit another vehicle. Only one that I barely, I wasn't even a dent on his. I had a little scratch on my fog light. That was it. Now, I just want to make that, you know, that's true, the truth, you know, about that. You know, I'm not hating, no cop pulled me over because I was out bobbing and weaving and, you know, like a habitual drink. I have not even drank that much. I've been with a nurse for 34 years. I don't get up in the morning drinking, you know, to deal with my problems. I've learned, I'm almost 60 years old. I know how to deal with my problems without alcohol. Yeah, I was on medication and all that, but I'm not a drunk out here at putting somebody at risk. You know, mad mothers, I know, I understand that I could hurt someone. I learned my lesson. You know, I broke my wrist up here in this jail, you know, and I was on medication and I mixed it with the alcohol. That was my stupidity. But as far as me trying to leave the scene of an accident and all that, that was not true. That was not true at all. They fabricate stuff when the police officer, they put anything in there, then they go with it. You know, they exaggerate. Yeah, I had DWIs back in the past and all that, but I'm not a violent person. I didn't try to leave the scene of an accident and all that. That is not true at all. That's all I want to make true, you know, for the record.
That they were putting out fires.
Right. Well, my original question was, did you have any questions? Not that you wanted to make a statement.
No, I just want I want the truth. You know, I want the truth to be told.
Right. Well,
I'm tired. You know, I'm tired. I know they got my record, got my number, and all that. And they keep enhancing, you know, all this kind of stuff. You know, they make money out. It's all a money market. I know that, but you know, this is my life. You know, they just. I'm not a guy here running over people and killing them like you know he just said I was. But I'm not.
Well, your purported truth may cause the prosecutor to keep prosecuting that other case.
If that's what he wants to do, that's fine. But that's the truth, though. That's the truth. I did not try to leave the scene of an accident. The truth is the truth, Your Honor. That's what you're supposed to go to court for.
All right, well,
that's the truth.
That's what we're here for. You pled guilty to the charge. And back to my original question to you, sir, do you have any questions? Not to make a statement. Do you have any
I just want to clear my name. You know, I don't like it being, you know, tarnished like that. You know, I just don't. That's not good.
All right. Well, you're entitled to all the credit you've been in jail so far, and you'll be remanded to the sheriff's custody. If the state does, in fact, dismiss this other charge, then that'll mean the paperwork on this case will get processed, and you should be put on a chain to go on to TDC pretty soon. If they choose to carry forward and prosecute that other habitual offender case, then they will keep you in the Smith County jail till we can get that one wrapped up. So I don't know what the future will hold, but again, you've got 30 days from today's date to file an appeal on this case if you wish to. If you don't wish to, you don't have to, but if you do, you've got that 30-day window and you'll need to make sure you comply with it. Otherwise, we have some people that wait a few months or a few years, then decide to try to appeal late, and I've never seen the appellate courts let them do it late whenever they knew about it early. So just make sure you think about that. Mr. Jarvis will be in touch with you to talk about that issue post-hearing today.
Okay, thank you, Your Honor.
You're welcome. All right, with that, I'll turn off YouTube, and y'all are free to go. We start back at 3 on the next matter.